Let me now get the the judiciary's angle here. Justice Sanjeev Banerjee is one of India's distinguished jurists, former Chief Justice of the High Courts of Madras and Meghalaya, joins us. Justice Banerjee, you might have heard Mahesh Jethmalani there making a defense in a way of his tribe of politicians, suggesting they are venting their frustration. They are not intimidating the judiciary. The Modi government believes in an independent judiciary. Your response?
Well, we've seen nothing overt to think otherwise. The government ought to and appears to believe in an independent judiciary. But there may be some loose cannons here and there, and one should not take everything that is said literally or attach too much seriousness to it. In public offices, judges are also open to criticism. Individuals are entitled to their opinions, and one should respect that for it as it is.
But I want an honest answer. Does this, what Nishikant Dubey said, according to you, amount to contempt or not? A direct attack on the Chief Justice, accusing him of inciting a civil war, and then suggesting that the Supreme Court is promoting religious wars across the country while the court is hearing sensitive cases. Is this not contempt?
Technically, it may be, but such scurrilous allegations are better left without being given any kind of dignity. One should not take up this matter and make an issue out of it, because that is exactly what probably the gentleman wants.
How do you're saying that Nishikant Dubey could well be a loose cannon, but what about when the Vice President of the country, who himself has been a lawyer, says Supreme Court judges have no accountability, that they are acting as a super parliament, that they are using Article 142 as a nuclear missile? This is the Vice President of the country. Should that not be a cause of concern?
It ought to be. To begin with, the office of the Vice President has to be respected. Secondly, and in all fairness, the matter as to the President giving assent or the time that ought to be taken by the President may not have been directly an issue in the matter pertaining to the Tamil Nadu governor withholding his consent or assent. That should have been left at that between the governor and the state, and not taken beyond to the President. Probably in due course, it will be taken to be an obiter rather than a binding kind of precedent. But of course, even an obiter of the Supreme Court is very important and significant. And the Vice President, as a lawyer, was venting an opinion, which he is entitled to.
But you see, the worry is that all these venting of opinions will eventually lead to some kind of a face-off sooner or later between the judiciary and executive. Isn't that a cause of worry and concern? I mean, if I'm sitting in the judge's chair, I'm always going to now look over my shoulder to see what is the executive or the Vice President going to say next.
I don't think any worthy judge does that or cares for what is said, as long as he does his job properly. Secondly, and more importantly, a slight friction between the judiciary and the executive or the legislative is good for democracy. It's always been. When President Roosevelt and the New Deal, ran into the Supreme Court ruling against it, he said he wanted to pack the US Supreme Court with yes-sayers and get rid of the naysayers. So it's all over the world. It's not, look at it as an isolated incident in India or in Indian politics or politicize it. But at the same time, I think that, some recent judgments or sayings by worthy judges have probably given an impression that the backbone that is necessary may not always be there. Some judgments of recent times have shown the same kind of character, let me say.
Yeah, but as we've seen with the two-judge bench verdict on governors, putting certain limits on their constitutional role and responsibilities, that seems to have at least given hope that the judiciary is out there to stop constitutional functionaries from acting in bad faith. And that should be respected by the executive instead of targeting the judiciary. Would you agree with that?
I would agree, but again, if the executive or the legislature feels otherwise, then they would bring about an appropriate law that might negate the judgment. and that they are perfectly within the rights to do it, and everyone is perfectly within his rights to kind of drum up support for such a situation. That
You
does
know,
not mean that there's disrespect. Yes, some of the words could have been better chosen. The obvious disrespect for the office or the position should probably have been avoided. But that doesn't mean there's any attack or there is any kind of planned thing to dismantle the judiciary or to demolish it or to intimidate it, as you use with
no,
Mahesh Jindani. Judges
no,
don't
no,
Good
I
judges
use the
don't get
word,
intimidated so easily.
I use the word also, Justice Banerjee, and you know this better than many, because all of this is coming against the backdrop also of the way in which there seems to be an unease in the executive and the judiciary over the transfer and appointment of judges. The collegium system coming under pressure. All of the, we had this instance a few weeks ago where cash was found at the door of a house of a high court judge. There seems to be a certain uneasiness, particularly when it comes to appointment of judges, their transfers. All of this is leading again, one fears, to some kind of a flashpoint sooner or later. Are you saying you're entirely sanguine that there won't be any such flashpoint?
The undercurrents have always been there, will be there, and they are there. Now, that is something which is the truth. But then one has to navigate it, and the judiciary must show the resilience that its position demands. Few attacks here or there, people expressing their opinion should be ignored. If at the same time, if you look at the judgment by the two-judge bench, you see recommendations made by Supreme Court collegiums, recommendations remade, which become binding on the government, have not been acted upon. So, therefore, probably in the light of the executive's conduct over the last few years, the judiciary felt it obligatory to set a time limit. Otherwise,
Right.
there's no constitutional time limit expressly said. But once the constitution says that if this happens, the consent should follow or the appointment should follow, the appointment has to follow. It can't wait for months or years thereafter. So, because of this kind of a reaction, because some of the recommendations by the collegium have not been followed, despite being re-recommended, the Supreme Court felt it necessary that now it's time to set some time limits.
Okay. I think you've raised several important points, and you've given a much more nuanced opinion. It's not black and white, and that is often the case in many of these tricky constitutional issues involving authorities like the executive and the judiciary. Justice Sanjeev Banerjee, for expressing your opinion. I appreciate you joining me. The judiciary versus executive face-off is something we will keep tracking. My own view is that members of parliament must be very careful in their choice of words. Nishikant Dubey, unfortunately, is a serial offender in that case.